knocking around the other night. Who do I find? On News Nation. But again, legal analyst and legal ninja, David Katz, here he was on News Nation.
Defense attorney David Katz, who served as a federal prosecutor and assistant U.S. attorney. Thanks again, as always, for being here. 18 months doesn't seem like that long. The armorer in the film getting about 18 months' time. But if this case proves guilt in terms of those charges, I mean, the prosecutor in the case, David, he originally dropped the charges, then refiled. How does this all work? What's the burden of proof?
Well, it has to be proven beyond a reasonable doubt to all 12 of the jurors down there in that courthouse in Santa Fe. It means everything, of course, to both sides. But Baldwin has hired Elon Musk's legal team. It's going to be a televised trial. We'll all be able to see it, unlike, let's say, the Trump trial in New York City. It's involuntary. He had no intention. He had no desire to hurt her. So actually 18 months, you could say, for involuntary manslaughter is quite a substantial sentence. It's the same sentence that the armorer got after she went to trial. And of course, he's going to defend that it's not his responsibility, and his actors union agrees with him. It's not the responsibility of an actor to make sure that there aren't live rounds in the gun. But at the same time, he says he didn't even pull the trigger. The prosecution has an expert who says that gun could not have gone off if he hadn't have pulled the trigger.
Okay, thank you, Albert. That's that's a taste of the magic that he brings to News Nation. But as you know, he's also heard on London radio and across the spectrum, CBS, NBC, ABC as well. We're so lucky to have him on Thursdays. David Katz, the former federal prosecutor, now the defense attorney. And so do you agree with most of what that guy just said?
Yeah, I thought that was a very cogent analysis. Remember, I was predicting before the trial started, Mark. One of the things that they were saying they were going to do was they had two theories. One, that Alec Baldwin had been personally negligent in how he had handled the gun, including they were going to present evidence, they will present evidence, that he did indeed pull the trigger. But second, they were going to argue that as one of the producers of the movie, he was responsible for the chaotic set, and it apparently had become a very chaotic set to the point that many of the crew had quit the day before, citing safety concerns. And then the very next day, this happened, and the cinematographer was fatally shot. The bullet went through her and actually did a great deal of damage to the shoulder of the director of the movie. And there's also two people who are cooperating against him, or at least one is cooperating against him, the assistant director. The assistant director is going to say that he actually pulled the trigger. And they're going to debate that back and forth. And in the opening statement, the defense kind of hedged their bets and said that even if he did pull the trigger, and remember when he said to the world, Alec Baldwin, that he had not pulled the trigger, and he was sure he hadn't pulled the trigger, and he never would pull the trigger, that he was under an awful lot of stress at that time, although he did make those same statements, Mark, later, again, to just about anybody who would interview him. So he may have been someone who's hoisted on his own petard by talking about it. And, we criminal defense attorneys, we always tell our clients, don't talk about the case. Don't talk to anybody. Don't talk to your best friend. Don't talk to anybody who doesn't have a privilege. And for goodness sakes, the news media doesn't have a privilege. At the same time, with his whole future at stake, he's such a high level celebrity that he felt that he had to do damage control and talk to the media. One last thing is that the judge did rule at the beginning of the trial that the prosecution cannot present any evidence that he's guilty or more likely to be guilty because he was one of the producers, which kind of makes sense because the other producers weren't charged. And the judge's logic was that the fact that you were one of the producers doesn't make it any more or less likely that you were personally negligent in how you handled that gun and how it went off.
Bravo, you just anticipated my question because I'm seeing in the chat everybody going producer, but he was the producer. And David Katz just told you, yeah, that's a carve out. It's accepted. It's not something that's rolled into this. So they are charging him as an actor on the set, then you're saying, David, who acted in a negligent way and in so doing brought about the death of someone unintentionally. That's why it's involuntary manslaughter, right?
The director and or the assistant director are going to say that he did things kind of his way, that they wanted him to take the gun out more slowly and carefully. He took it out more quickly, that somehow in hitting the hammer, he says it must have gone off. But again, they're going to have a witness who's going to say that no, that witness saw him pull the trigger. They're going to impeach the witness. This is why people love criminal trials, because there is two sides to the story often. And if there's too much two sides to the story, they're going to find him not guilty, because they have to find him guilty, all 12, beyond a reasonable doubt. But someone's going to say that he did, in fact, pull the trigger. He's going to say, well, that person made a deal with the prosecution to serve no jail time. Baldwin's looking at 18 months. The armorer went to trial and got 18 months. Here's someone who got no jail time. They would tell on Mother Teresa to get a no jail time deal. And back and forth it will go. As I said before, Alec Baldwin has very expensive, very good lawyers. There are also two prosecutors on this case, and people will remember the history that a lot of people just hate Alec Baldwin because, you know, he played Trump and ridiculed Trump, and the Trump backers kind of hate him. The Republicans have kind of come to hate him because of that and because he's a progressive. And so he was actually being prosecuted by someone a couple of years ago who had a conflict of interest, because she was also a Republican politician in the state of New Mexico. She got off the case. The case kind of languished for a while. You might have thought that he was kind of in the clear, and then all of a sudden he got charged again. I love the commentary on some of the stations that don't like him that said, oh my God, then the grand jury looked at it and charged him again. Mark, I've always said, being charged by a grand jury in America, they'll charge a ham sandwich. The grand jury was supposed to be a real block against prosecutorial overreach, and it's not that anymore. It's just become a rubber stamp. And so the fact that he was charged by the grand jury doesn't really matter. The fact that the prosecution decided again to go on it, that really does matter. My Katz prediction, I don't think he's going to be found guilty there. It's one felony count.
Wow.
It's one felony count. We've talked about this before, about a year ago, with another celebrity who was, I don't think he was in the dock. I think he was suing maybe, or he was being sued. Anyway, that celebrity, he's a big music star. He won his trial, and you said to me at the time, so maybe there was a celebrity factor. I do think it's very difficult. I think celebrities, everyone should walk into a courtroom, especially a criminal courtroom, with a presumption of innocence. But I think especially a celebrity like him, even the Republicans who may not like him, who may be on the jury, I think he walks in there with a presumption that he's a great star, he's a great celebrity, he's not somebody, even involuntarily, who intended or even acted recklessly in killing somebody. And I think there's another issue in the case, which I don't want to be too inside baseball, but the analysis of this gun is very important. And the FBI analyzed this gun, and, you know, stuff happens, you know. I used to work with the FBI. They were on my side, along with the IRS, the postal inspectors, and generally they did a great job. But things happen, and in analyzing this gun, they broke it. And so it can't be analyzed by the defense team. And I think somehow they'll get that before the jury. I think when you're asking someone to be found guilty of a crime, face 18 months in prison, Mark, I think it is relevant to consider the fact that he cannot test the weapon. And so you have to take the government's word for it. And beyond a reasonable doubt, you shouldn't take the government's word for it. And that maybe it really did go off because he pulled the hammer, he pulled it out fast, and somehow this gun went off. And the FBI said, no, that couldn't happen. But he didn't have a chance to have his own expert test to see the same kind of test the FBI did, because the gun was destroyed in the course of the FBI testing of it. I don't think they're going to find him guilty beyond a reasonable doubt. Could be a hung jury, but, you know, every time we predict a hung jury, there are relatively few hung juries. They sit around, and generally the majority does convince the couple of dissenters. You see how few of these cases, I've had them myself. And I think if there's a strong narrative on both sides, you can have a hung jury, but they're rare.
I'm just noticing in the chat sort of and what I really like about this conversation so far is that you've really focused us on the thing that it's easy to kind of lose track of, which is he's being tried as the actor on the set who handled the weapon, not as the producer on the set who's responsible for cutting costs and for the general chaos that was affecting that set. Heather says, Why even have an armorer if they're still going to hold the actor accountable? If the armorer handed me a prop gun, I would assume it was okay to fire because that's the armorer's damn job to check it.
Over July 4th, we were talking about this with some very smart non-lawyers. And they said, if he'd have put that gun to his own head and pulled the trigger, wouldn't he have been more careful? That may end up being an argument by the prosecution.
That's why you're a great lawyer. All right. David Katz, let me move on to another sort of, I'm going to call it a sideshow, but I don't mean to trivialize it this way, because I think Rudy Giuliani is trying to get away from paying these debts to these people that he's defamed, those poor Georgia poll workers, et cetera. And now the judge in his bankruptcy case is ready to, he's smack-talking Rudy in the courtroom, and he's hinting at the fact that there might be a dismissal of the bankruptcy. New York federal judge poised to dismiss Rudy Giuliani's bankruptcy case, expressing concern yesterday that Giuliani has used the proceedings to obfuscate his assets and delay paying a massive defamation penalty to 2 Georgia election workers. This is a quote from the judge. "I'm leaning toward dismissal, frankly, because I'm concerned that the past is prologue. The difficulties that we've encountered in this case in terms of transparency will continue and dog the case." The 2 Georgia women, I'll remind you, Ruby Freeman and Shay Moss, won a $148 million judgment for defamation against Rudy. Can you speak to this?
Well, Giuliani, America's disgraced former mayor, right? Remember, he was America's mayor, and now he's like America's like total oddball super advocate for Trump. He and I believe Trump tacitly, at least, agreed with this as part of Trump's election interference back in 2020. They destroyed these women's lives. What they did to these women's lives, you wouldn't want to do to your worst enemy. They had like a lynch mob going to their house. They had to move out of their homes. They were recognized at different places and lived in terror on account of this. And the account was totally false. All they'd been doing was working as poll workers. Who would want to work as a poll worker and do that public service after this harassment, or worse than harassment, this really terror that they were inflicted on, because Giuliani ran his mouth and kept saying that they were, stuffing ballots, they were doing improprieties, they were stealing the election. Remember, Georgia was so close, it was only 11,000 votes. It really mattered if a bunch of poll workers like them were doing what they did. So they ended up suing. They ended up winning. There's a lot of reasons why there were both compensatory and punitive damages, punitive damages against Giuliani. Now, bankruptcy court is a good thing for debtors like Giuliani. You want to go into bankruptcy court. The other alternative is that all these people put liens and levies on your accounts. They foreclose on you. Everybody attacks you at once in civil suits, and you lose, right? They enter a judgment, and the next thing you know, if you live in an apartment, expensive apartment like he does, they put a lien on it. So bankruptcy court is the partial salvation of debtors. And what you want is you want to get a discharge. You want your debts to be discharged so you can make a fresh start. That's what Trump managed to do with his company and make a fresh start after he, bankrupted all those casinos. He could walk away from it. Giuliani has some companies, but Giuliani's goal in this whole thing was to try to walk away from it. So what he doesn't want, what he wants is a discharge. And let's say they pay the people 5% of the money, but that's all you can pay. And then you walk away and you can make a fresh start. That's not something that's in the cards for Giuliani, because Giuliani is going to get a dismissal. A dismissal means you don't get the benefit of the bankruptcy court. Yes, you don't have to deal with a trustee, but you don't get any of the relief. So in other words, if he gets dismissed on today, on Friday, these women and their lawyers who have this huge judgment can go put a lien on his condo. Now, he's probably trying to sell his condo or transfer his condo, and all of those can be fraudulent conveyances. They can be attacked civilly, and maybe some of that's even criminal. I don't know exactly how that would work out, but Giuliani has some criminal peril in all of this, and he's going to have all of these judgments that people are going to run and try to enforce any way that they can. one thing is if you have a trustee and the trustee says, well, you have to live on $10,000 a month. Some people are going to say $10,000 a month. You're bankrupt and you're allowed $10,000 a month. But Giuliani's supposedly spending a whole lot more than that. And he doesn't want to have a trustee. And again, they'll go court after court and they'll do what are called creditors' remedies that they can do. But Giuliani will not have the protection of a bankruptcy court saying, stop, slow down. Let's do something that works for everybody. And one last thought on this. It looks like it will be the women who collect most of the money if there's money to collect, because the smaller creditors probably don't have the resources. It's not worth their while, right? The bang isn't worth the bang isn't worth the buck, or whatever the expression is, to go chase after him, because they have to pay a lot of lawyers, and how much will they get? Whereas in the bankruptcy court, there's one hearing, you can go in and you can go get 5 cents on the dollar. Now, you may not have much sympathy for some of his other creditors. A lot of them are these lawyers. He ran up millions of dollars in law bills. And apparently these lawyers who knew him from the U.S. Attorney's Office from the Southern District of New York thought it was a great honor to represent America's mayor, even as he became such a symbol, right, for overbearingness and worse than that. But they represented him and they gave him credit, and now he owes them millions of dollars. I would not have, I don't know if I would have represented Giuliani, but I sure wouldn't have represented him on credit.
And it's interesting. Usually, lawyers make sure they get their money up front. But with Rudy, as you say, he was sort of skating on rep. I think he's been dining out on that, America's mayor crap for, decades now. But interesting because it sounds to me like, and I just want to make sure that he can't appeal this, like this will be the final decision. In other words, you throw away the bankruptcy, that is to say, you deny him the bankruptcy protection. He can't go to a different court and try to get bankruptcy protection from some other court in New York.
He could try to go to, like, there's a bankruptcy appellate court or a bankruptcy appellate panel, or he could try to go to the other federal courts. He could try to go to a district court or to the U.S. Court of Appeals. But that's, first of all, he doesn't have any issue on which it appears that he would win or that he could delay things or get a stay. And beyond that, he asked actually for the case to be dismissed. So you can't appeal what you asked for. That's called an invited error. And he invited this disposition. He wants out. Now, what he thinks, I believe, is that he can hide the money well enough to make it really difficult for his creditors, and that he has a better chance hiding from his creditors his assets in all of these trusts and what have you. Maybe some of them, maybe many of them are offshore. And that raises complications, or maybe they're in some sanctuary country. I'm a federal criminal defense attorney now in these kinds of cases, these IRS cases that go beyond an audit mark and become criminal investigations. And that's often what the badges of fraud are, that money has been put offshore, it doesn't make any sense, and that's part of the criminal intent. And like I said, Giuliani may have those kind of problems. And, the fact that he's 80 years old, a lot of people think, well, he won't get indicted because he's 80 or 81. Don't believe it. When I was a federal prosecutor, I indicted a guy who was 80. And my boss said, he's never going to get any jail time. I show up in front of the federal judge. He tells the federal judge how old he is. The federal judge says two things. Number one, young man, I'm older than you are. And number two, you tell me you can't do the time? Do as much as you can. And a lot of federal judges have that attitude. Do as much as you can. Giuliani made those women's lives miserable. If he committed other crimes, you don't get if you're very ill, you do. There's compassionate release. There is some compassion in the system for someone who really has, let's say, a medical, analysis that they only have 6 months to live. Or, there are really compassionate situations for people in prison, and we shouldn't make light of them. I believe strongly in compassionate release. But for somebody like the fellow that I prosecuted, who had, tubed a bank and destroyed a lot of people, they weren't protected by federal insurance, many of them. They were fairly substantial investors in the bank. They'd lost their life savings. Someone like Giuliani, who, threatened the lives of those women with his false rhetoric. Don't think because he's 80, 81 that he wouldn't get a prison sentence if he gets convicted.
I've made my view of Rudy Giuliani. He's rotten to the core. There's no punishment severe enough for him and what he did to those sweet poll workers. And my heart breaks for them. And I hope that justice is served as best justice can be served in our system. Alito and Thomas, get impeachment articles filed against them. This is, again, in the Republican-run branch of government right now, which is the House. It was AOC, the Democrat of New York, who introduced articles of impeachment against Justices Clarence Thomas and Samuel Alito, Jr. The argument is, and in these filings, they're accused of improperly failing to disclose gifts from wealthy benefactors and to recuse themselves from certain cases before the Supreme Court. It would seem as though this is manifestly true. There's no realistic chance, of course, of, the impeachment going forward. That's why I mentioned this Republican-controlled House. But I like that this is out there because it does, in a little bit of the news cycle, put a light on what's going on at SCOTUS.
I think that that's so. And I think it's one of AOC's, moments to show, where she thinks that our polity should go. And, they have impeached and they've actually convicted in the Senate many federal judges. And for just the sort of thing that Clarence Thomas is being accused of. I don't think the recusals so much. I think that is a bit of a bridge too far. Maybe even if I were a U.S. Senator and I had to vote on the impeachment articles that arrived, would I convict? I'm not sure that I would convict for the recusals, especially
let me just follow up on that, though, yeah. David Katz, because you're dealing with someone in Clarence Thomas's wife who was involved in January 6th in a very active way, and yet you're going to not include the fact that he refused recusal.
I was about to say for Alito.
Alito, I'm sorry. Okay.
Alito and the flags flying. But, however, I agree strongly with you, Mark, that the recusal for Thomas is something that I think that it was so clear. His wife was so directly involved in that. They pointed out that it does not have, they say, for federal crimes and misdemeanors. And so the argument would be that it's not a federal crime or misdemeanor not to recuse, that personal interest that you have, I don't know, it could go either way. I'd actually want to hear what some lawyers had to say if I were a senator, whether that conduct constituted a high crime or misdemeanor. I'd be, if it weren't a high crime or misdemeanor, then I would think that I couldn't vote to convict on that, even as to Thomas. But taking his taxes, which I think are a part of this, the taxes are certainly a high crime or misdemeanor. Having said that, Mark, generally speaking, those are not prosecuted. The fact that someone has, they have a forgiven loan in a year, and the amount is $270,000. This is over the RV that's as good as a second home. And so let's assume for a second that it's true, that he gets a loan, he and his wife both get this loan, Clarence Thomas, so he can buy this very expensive RV. And then he pays on it for a while, basically just paying the interest. And then the person who gave him the loan, an old friend of his, that's at least not someone like Crow. That is at least someone that he was friends with. This old friend of his forgives the loan, says you don't have to pay back any of the principal. Now, these two senators wrote to Clarence Thomas, and his counsel basically stonewalled and said there was a separation of powers problem where they're answering any of the questions. You want to take that tack, you're very likely to have a special counsel appointed, and you're very likely to have a Democratic House think that you ought to be impeached because you had your chance to explain it and you didn't explain it. So if you have $270,000, that's a relatively small amount. Generally, the IRS wants 3 years in a row of illegal conduct before they make the discretionary decision to recommend indictment. So if Thomas didn't do it 3 years in a row, that would be a little unusual. $270,000, you can say, is a small amount for a lot of business people, right? But for a Supreme Court justice who should be held to a higher standard, there's no reason why that couldn't be the basis of an indictment. And the fact that he left 3 of the trips off of his form, to me, that's not an impeachable offense. To me, if you leave something off a form, even though Thomas had a lot of staff and aides and people like that, to me, I don't know, that's not clearly criminal. If I were the special counsel, I don't think I would indict him. Recently, he did file a form, and on the form, he still left off 3 of the trips. They only found out about them because Crow was smart enough to hire a good lawyer and said, look, I don't know if a Supreme Court justice can get away with this, but I'm sure not going to take my chance of getting away with it. I'm going to hire a good lawyer, cooperate with the Congress. This fellow Crow cooperated with the Congress. He turned over his records, and lo and behold, there were 3 trips that on his certification, Thomas had not included. Still, you know what I mean, Mark? Leaving 3 things off a form, which did have a lot of stuff on it, to me is not criminal. So I think all of this at the end of the day, Mark, if they appointed a special counsel, first of all, I think that Merrick Garland will make an analysis very much like mine, although he'll know more. I don't think he'll appoint a special counsel. If he does appoint a special counsel, I don't think the special counsel will actually indict Clarence Thomas. And the reason I say that is if you look at the cases that the special counsels have indicted recently, you can say, well, Hunter Biden, my God, they went after Hunter Biden. Why? It's shoes on the other foot. Why don't they go after Clarence Thomas? But on Hunter Biden, they had a form that they could say, here's the form. It was clearly false because Hunter Biden had written a book saying that he was on drugs all the time, that the form said that he wasn't on drugs. He had to actually parse certain days, Hunter, to try to be found not guilty beyond a reasonable doubt. The case that's about to go in, brought by the special counsel on the taxes, to me, that's a pretty strong case. You may say that
these are the, just to be clear, those are the taxes on Hunter Biden. You've now segued to Hunter Biden, right?
I'm talking about cases brought by the special counsel.
Yes, okay.
That hits me as a case that's pretty clear. I think the case on Mar-a-Lago brought by special counsel against Trump is exceptionally clear, as is the case against the 2 aides to Trump that helped him allegedly, hide the documents, move them around, to try to fool the FBI and the federal investigators looking into the Mar-a-Lago, which are national security documents with their top secret labels right on them. And then you look at her investigation of Biden. There was a special counsel who, he said mean things about Biden's acuity, but he didn't indict him. So what I take from that is that the special counsel system, I think, is working to the extent that a Clarence Thomas, because all those cases are close. Again, I'd want to have the legal opinion of not recusing on his own and his wife's case, but on the tax, the 267, and on the leaving the 3 trips off the form, I think the special counsel would not indict Clarence Thomas. They can impeach him, and if they had 67 votes in the Senate, they could remove him. And believe me, they got an awful lot. There's no reason in the world, I don't think, why they couldn't just, if these are high crimes and misdemeanors, I want a legal opinion on that. There's no reason why, if the House voted articles of impeachment, there's no reason why the Senate, except for that one caveat, couldn't remove him. That's the penalty. He'd be removed, and another U.S. Supreme Court justice would be put in his place. By that time, might be someone picked by Trump. I hope not.
Yeah, exactly. Just because you've mentioned it, let me just ask you an off-the-wall question. Eileen Cannon, who's the Trump-selected judge who's protecting Trump from the trial and evidence that is so damning that it would immediately affect, I think, poll standings, et cetera, politically explosive. It's the jacking of the documents, the thousands of documents, top secret documents, military secrets, et cetera. That judge cannot be replaced by the President of the United States, right?
Cannon?
Yeah.
No, that's the separation of powers.
Right.
And so the president, anyone in the executive authority, has no control whatsoever over the judges and whether that judge should be, let's say, removed in favor of
just to call back to the Trump administration, when Trump was sweating the Southern District, he was really, meaning sweating them, meaning pressuring them, complaining about them, talking about how they have a policy of harassment there, forced or helped force, my foggy recollection, helped force a resignation, or at least maybe it was the Cy Vance thing. You'll have to remind me. But I guess what I'm asking is, the executive, even if no direct power exists in the executive to pluck a judge out, can they help exert pressure to affect a change in a judiciary in a state, or not really?
No, not at all. Okay. In a state, of course, the president has no power in a state over the state courts, and a president has no power over the judiciary. That's the independence of the judiciary. That's the separation of powers. That's why, like this ethics rules, even there's a question whether only the judiciary can impose rules on itself. Now, everyone has to obey the criminal law. And so that's why if Thomas submitted false tax returns, if he got, I suppose that the perfect case would be some witnesses who are not protected by privilege come forward and say, Thomas knew very well that he'd received $300,000 that year because the amount was written off. He knew very well that he was supposed to report that, and he didn't report it. And he pocketed the, what is the tax? The tax, let's say it's 40% altogether for marginal income at his tax bracket. And so, that's $120,000 if I did that right, that he pocketed. You or I pocketed $120,000. I think the reality is that we'd have to do it 3 years in a row, generally speaking. And if he did it for 1 year, if he took enough money, there was the famous guy who won a prize, Mark. I don't know if you remember this guy, one of those shows. And the guy won $1 million. And he said, wow, I get $1 million. That's great. He didn't file a tax return. He didn't do anything. He just took the $1 million and spent it on wine, women, and song and blew off the IRS. They indicted him, even though it was 1 year. It wasn't 3 years in a row that he did it. It was 1 year. And, but you see the difference between what Clarence Thomas did maybe and that guy did. And, $1 million then is like $2 million now. I just don't think the special counsel, anyone who's waiting for that to happen, if they're expand the Supreme Court, if there's enough votes, right? All they have to do is to have a majority of the House, which the Democrats don't have right now, and then say that this is not one covered by the filibuster. They approve U.S. Supreme Court justices by a mere majority. They should be able to increase the size of the Supreme Court by a mere majority in the Senate. It's not covered by the filibuster. They could have done that when they
absolutely
had both houses.
And Republicans,
Sinema and Manchin wouldn't have gone for it, and so and probably one or two others, and so they didn't really have 50 votes to do that with the vice president. They never had 50 votes to expand the size of this Supreme Court. But I
don't know that you had the political will on the part of the institutionalist that is Joe Biden either, but it would have been the move, such a huge move tactically. But
well, these last couple of years, Mark, can I just say, the last couple of years, if you look at what's happened, Dobbs overturning Roe v. Wade after 50 years that it was the law of the land, then they got rid of affirmative action the next term. Something that has been in effect since LBJ. And then this term, a complete disaster. And one of the ways you can look at this term, I've said before, I have a lot of respect for the judiciary. I have my real doubts, though, about some of the justices on the U.S. Supreme Court, who I think were looking in the mirror, Mark, and they were saying on some of these decisions, like the bribery one, before anyone comes after me, I'm making this quid pro quo very, very clear that they have to not just have a quid, but a quo, and it's so hard to show. And I think they were looking at themselves in the mirror. This is, again, I have a different view of Alito than I do of Thomas, but I think Thomas was absolutely looking in the mirror and saying, if and when they come after me for bribery, I'm going to help create a precedent that helps me.
Crazy. Just
you look at the way that they've gone. You look at the way that they've gone on these bribery cases, and they could accuse a Supreme Court justice of a bribe, just like they could a Congress member, or just like they could a governor. And every case makes it harder to prove bribery. Every case the Supreme Court's had the last few years, and presidential immunity. I won't even mention how wrong I think that case is, and for so many reasons. This is not an autocracy. This is a democracy.
The comment that I want you to weigh in on, because I think this happens a lot around impeachment. You hear this. Doug says, I think His Honor, Mr. Thomas, is not guilty of any high crime or misdemeanor. Can anyone name one? And I remember talking to my father about this, who was a constitutional lawyer and very erudite man, and his view, but it doesn't have to be the view. I'm happy to hear it. You may disagree. He said, yeah, because I was railing about Trump. Okay. And he goes, Mark, the high crime and misdemeanor thing, it's so interpretive. He said, it really is. There are all kinds of ways to look at somebody's behavior, lack of recusal on the part of this case with Thomas, et cetera, and say that's a high crime or misdemeanor, that you're in collusion with your wife, et cetera. He said, but the reality is that because it's interpretive, it leaves a lot of room, a lot of wiggle room. Can you speak to that?
Well, first of all, Mark, I'm sure you miss your dad very much. And I lost my mom in November. And it's tough, right? They've been there so many years and such a huge influence on us. So I'm liable to agree because it was your dad's view. I'm liable to agree with any view that was my mom's view that anyone puts before me. But and by the way, my mom spoke with Pat Thurston and Kim on Mother's Day a couple of years ago and said hi. And my mom was a professional dancer, and I was just thinking of that right now with Kim. I don't know if you remember that on Mother's Day with Pat about 2 or 3 years ago, but it meant so much to my mom, and she loved speaking with both of you on Mother's Day a couple of years ago. Anyway, to answer your question, Mark, it's absolutely true. And the tax thing is a high crime. If you had that evidence that he got $300,000 forgiveness of a loan, you know, he's no guy walking down the street who forgiveness of a loan. What's that all about? Or, you know, my mom gave me $1,000 and I didn't pay her back. And that year she said, it's fine, don't pay me back. That's not what we're talking about. It's $300,000. He knows very well that if you have a loan forgiven in a year, in that year you have income and you've got to report it. That would be a perfectly proper basis. And there have been federal judges who have been impeached and who have been convicted and removed from office for tax crimes. In fact, that's probably the most common one. On the recusal, I hear what you're saying, and as part of a conspiracy to get your wife out of trouble, I just would want to have a legal opinion on it. It's hitting me right now.
Sure.
Your dad didn't happen to leave a legal opinion behind, did he?
No, he was, he was making a general point because I think you run into this with the word treason as well. People go, it's treasonous. You can try him for treason. Again, treason is a really interpretive kind of term. I mean, these are great hot button things to throw out: high crime, misdemeanor, treason, etc. But the reality is that the law is somewhat interpretive and general and leaves a lot of shimmy room, it seems, on some of these things.
Didn't you have to have 2 direct witnesses to treason? I somehow remember that. It couldn't be hearsay, it couldn't be circumstantial or something like that. Treason, incredibly hard to prove. But you know, on this issue that we're talking about with the removal, it just, you know what I mean? You just imagine it. It's just very, very hard to imagine it happening. That's all.
But I like the fact, and it's been noted in the chat, and we have to wrap up. But I like the fact that it keeps it out there. I was making the point before a few minutes ago. It keeps it out there. It keeps a reminder of how corrupt the court is. It keeps a reminder out there of their toxic decisions and the toxic decision-making process. Can I leave you with a legal palate cleanser that has nothing to do with this stuff, but it is related to Biden and Trump, and here's what it is. The story comes out of Tennessee. A federal judge has ruled that a Tennessee woman has a constitutional right to post a yard sign with profane language condemning both President Joe Biden and former President Donald Trump. Julie Pereira set up a sign in front of her yard saying, F them both, 2024, only it wasn't F, it was the full word. And the city of Lakeland, which is a northeast suburb of Memphis, fined her hundreds of dollars for violating a regulation against obscene content on signs. She filed a lawsuit saying she was dissatisfied with both presidential candidates and that she wanted a sign that spoke simply to that fact. And now the U.S. District Judge in Memphis says that her political sign is not obscene and she's allowed to have it. Comments?
Didn't Neil Diamond have a song, Tennessee Woman? Maybe this was a Tennessee woman that he had in mind. There was a famous case that everybody remembers from law school where someone has a sign, F the draft, except it spells it out. And the Supreme Court said that in that context, it was expressive conduct. So this was actually fairly predictable. I don't know. I can imagine someone having, to look at it the other way. Someone has F Black Lives Matter. Okay, it's enough that they don't agree with Black Lives Matter demonstrations or protesters, but now to add the F word, it's a little bit fighting words. I don't mean to sound so square, but the F word is kind of a fighting word, and some other words like that. You can imagine some of the other, there aren't that many dirty words as George Carlin made famous. But think through some of those dirty words and think of them being on a huge sign or billboard. I kind of get where the city was coming from. It seems to me that you can express that sentiment by saying F, asterisk, asterisk, K.
Sure.
But yeah, it's a fascinating thing that it went that some lawyer made, I think, $40,000 in attorney's fees representing that Tennessee woman.
Well, the judge's order comes after the city agreed to a settlement with her of $32,000 for her legal fees and reimbursing nearly $700 in fines. And just for the record, I'm with you. I used to be president of a homeowners association, and I know about it. Dude, we don't need that on the front lawn. Can we? I mean, I get it, but can you, as David Katz has said, can you put F both of them as opposed to the actual word? I love seeing you in all of these places. News Nation is the latest to follow the Baldwin thing. How long a trial will the Baldwin trial be?
I think it's just going to be a few more days. I think it's unlikely that Baldwin would take the stand. I think that he's probably ahead right now, proof beyond a reasonable doubt, very high standard. And then he's going to have, this is what News Nation, News Nation's the show that Cuomo is on now.
Sure.
And it's a nationally televised. I at least get it on 16 on Spectrum.
Yeah.
And I did want to mention one other thing, if I can, Mark. I'm very involved with the LA Law Library, and they're doing a thing now called Clear Your Record. And it was just on KNX today. They're doing some public service announcements. And I'll remind people next week, but a week from tomorrow, I'm speaking at the LA Law Library on this subject. And it's how you can, there's some things where the state's supposed to clear your record, like marijuana cases and things like that, where the state does it. But there's a lot where you have to take some initiative. You don't necessarily need to hire a lawyer. You can fill these things out, and the LA Law Library will help you do it. They have a lot of staff, and so we're publicizing that. It's an important thing for people to get a fair crack at a job. This is not to be an assistant U.S. attorney or an FBI agent. You'll still have a withering exam of everything you've done in your life. But to get a job, and a lot of people have something on their record, it'll come back that you either will have a clean record or it will say dismissed on your record. And there are also some provisions where you're legally allowed to say that you haven't had a prior arrest or conviction. You're allowed legally to answer that question, no. But of course, people want to be sensitive to make sure that they're doing it the right way. So we're publicizing that at the LA Law Library, and I'm going to be speaking on that a week from tomorrow. And I'll let people know in your next show next week how.
Yeah, give us a website so we can post it. I think it's I think it's something that people would have an interest in who are in Southern California. We have a lot of listeners and viewers in Southern California. In the Baldwin trial, this is breaking. A crime scene Texas. She found live rounds of ammunition all over the Rust movie set after the cinematographer was killed. Yeah, but again, I think just
But Mark, how does that go? Because if he's not a producer and they're not allowed to know that he's a producer, okay, he was an actor on a set where there was a lot of sloppiness going on. He may even say that, well, that's again on the armorer. That's on all these other people. There's on these people who are testifying against me. Look at how sloppy it was. I mean, in that sense, you can say that he's exploiting that ruling in his favor. But that's what trials are about, trying to have that balance between what's prejudicial and what's probative and what's too prejudicial. And the judge said that him not being, the prosecution not being allowed to say that he was one of the producers on there, that's in the interest of justice, that would be more prejudicial and misleading because it's really about his personal negligence, his personal recklessness or not as an actor.
As an actor, I think that is one of the real takeaways from today's conversation with you. For all of the ways in which, he was a producer, so he's responsible for the set. All those various ways in which those details are folded in just don't matter, at least in this legal case, and in the case in which he's being tried.
He's being sued. He's being sued out one side and out the other, I think, including by Gloria Allred. So he's being sued quite a bit. He's got this show coming on. He's trying to sell his multi-million-dollar mansion. Alec Baldwin is somewhere. So
Alec Baldwin's doing just fine. He's got plenty of money. He's doing just
fine, and there is a family that was devastated. There's that cinematographer's family and that director who was also hit by that bullet.
Yeah, so true. Thanks, David. David Katz. See you next week.
Pleasure's mine. Thanks.
Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped. And please subscribe to our channel to help us save the universe.